I've given an overview of the Constitution and have discussed the enumerated powers of Congress. Before I get deeper into the details of the Constitution, I want to address the idea of the Constitution being an evolving, changing document. I'm sure you've heard those terms before. If this idea is true, why would we care what the founders thought or said? We would want to interpret things in light of today's environment. Is treating the Constitution as evolving a legitimate view? It is certainly a popular view today, but there are certain problems with that view. It is mutually exclusive with the other view of how to interpret the Constitution, the originalist view or original intent, or sometimes called the strict constructionist view. Can both views be correct? Well, absolutely not. Here's an illustration. Suppose two parties signed a contract. One owned a factory and the other wanted to rent it. The contract stipulated that the renter would pay the owner a sum of $1,000 per month for the duration of the rental agreement, which was 20 years. Everything was fine for the first 10 years. Then the owner realized that the factory was worth much more than the $1,000 per month that he was getting in rent. So he took the renter to court and demanded the current market price of $2,000 per month. What would you think of a judge who said that he must look at the contract in view of today's situation and ruled for the renter, forcing the renter to pay a higher fee? What did the judge actually do? Well, yes, he totally negated the contract. A contract is worthless if someone can arbitrarily change it. Some may say that this way to interpret the Constitution is as legitimate a way to interpret as the strict constructionist view. Well, what's the correct way? The founders' view, therefore the correct view, is the original intent interpretation. The idea that the Constitution evolves as determined by courts is foreign to our founding fathers. Our Constitution was seen as a fixed standard, alterable only by amendment. They thought that the changes would be slow and gradual by amendment. What did the founders say on how the Constitution should be interpreted? The basic rule of law at that time meant that you interpreted any contract, which Constitution is a contract, by the intent of the ratifiers. James Madison, considered the father of the Constitution, said, "I entirely concur in the propriety of resorting to the sense in which the Constitution was accepted and ratified by the nation. In that sense alone is it the legitimate Constitution. And if that not be the guide in expounding it, there can be no security for a consistent and stable more than for a faithful exercise of its powers." James Wilson, one of only 6 to sign both the Declaration and the Constitution, said, "The first and governing maxim in the interpretation of a statute is to discover the meaning of those who made it." Eldridge Gerry, another Constitution delegate, said, "The people of America can never be safe if Congress has a right to exercise the power of giving construction to the Constitution different from the original instrument." Joseph Story said that the first and fundamental rule in the interpretation of all instruments is to construe them according to the sense of the terms and the intentions of the parties, and that the reason and spirit of the law or the causes which led to its enactment are often the best exponents in the words and limit their application. The Constitution is not to be subject to such fluctuations. It is to have a fixed, uniform, permanent construction. It should be, so far as at least any human infirmity will allow, not dependent on the passions or parties of particular times, but the same yesterday, today, and forever. If the courts can decide the true meaning on the Constitution based on their own thinking instead of the intent of the ratifiers, then the Constitution has no real meaning. How did we get to the point where we consider the courts the ultimate authority? It actually started in the evolutionary mindset that crept into the legal system. Before 1850, most lawyers were not trained in law schools, but were apprentices in law offices. That started to change with Harvard Law School in the mid-1800s. Harvard President Charles Eliot and Harvard Law Dean Christopher Langdell both believed in Darwinian evolution and began to incorporate Darwinian principles into their law school. This system rejected laws coming ultimately from God, as taught by William Blackstone, and accepted by our founders, and created the case method approach to teaching law. The case method required students to collect and study opinions written by judges in legal cases. From these cases, using human reason, generalized laws could be extracted. This, in essence, trained lawyers to practice progressive evolutionary law, where the judges were the ultimate authority, not the Constitution. Oliver Wendell Holmes championed this view in the Supreme Court in the early 1900s. This case method view has now permeated virtually every law school in America, so that when you study the Constitution today, you will study all the court cases that decided what the Constitution means. This case decided that case decided this. We no longer study the original intent of the Constitution, but what the judges have decided the Constitution says. This is what we hear, that the Constitution is an evolving, changing document. We've accepted what former Chief Justice Charles Evan Hughes advocated, that the Constitution is what the judges say it is. Also, the view that the courts are the final authority is part of this philosophy. If you approach the Constitution in this way, what Judge Hughes says is true. What does this approach make the Supreme Court decisions? It makes it the supreme law of the land instead of the Constitution in reality. And in reality, it makes the judiciary the strongest branch. If we acquiesce to the notion that our modern interpretation of the Constitution is okay, we have lost the battle. We must try to regain our original Constitution if we are going to save our nation. It is going to be a long battle because we didn't get here overnight.